Please be seated. All right, third and final case on this morning's docket is 23-1402, Kun Zhang? Zhang? Thank you, sir. Versus Ocala Heart Clinic. Again, 20 minutes per side. Appellant can reserve as much of that as you would like for rebuttal. Default is set at 5 minutes. If you want something other than that, just let me know, okay? If you're ready, counsel, you may proceed.
May it please the court. Tim Sobchak on behalf of the appellant, Dr. Kun Zhang. I'd like to reserve 3 minutes if acceptable. My client's challenged a number of issues with the trial court's amended final judgment that was entered after a 2-day bench trial. I'm going to start with what I think is the most critical and clear error by the trial court, and that concerns count 2 of Appellee Ocala Heart, which I'll call OHC's counterclaims, and count 2, OHC sued my client for the balance of the membership interest of approximately $270,000. And the trial court agreed and granted judgment in OHC's favor. The error is that the trial court already found that OHC committed a prior material breach of that exact document. Under count 1 of the amended complaint, my client sued for breach of that document in OHC's failure to pay the tax distribution to him of $23,000. The trial court agreed with my client and awarded damages to Dr. Zhang of $23,000 and expressly found he was the prevailing party on that claim.
And so let me interject before we go further in that regard. Is it your contention we're here under a de novo review, or are we looking for whether or not there's competent substantial evidence to support the trial court's findings?
On that point, it's de novo, because I believe it's a misapplication of Florida law. I'm not asking the court to second guess any findings of fact on that issue. It's already stated in the amended final judgment. I think the court just simply did not apply what I think is basic Florida law on prior material breach. Okay. So I believe it's de novo. And I think it's undisputed, and why I don't believe we're asking the court to evaluate facts on that point. Section 6.2 of the operating agreement required the tax distribution on or before March 15th, 2018. That did not occur. It's undisputed it didn't occur. That's what the trial court found was a breach. My client continued to work for the next couple months and continued to pay his membership interest through the monthly installments all the way until his last day on June 15th, 2018. So it's undeniable that the breach occurred first by OHC, and the moment that happened, I think Florida law, Florida law compels the trial court to find that my client's discharged of obligations. And so what we're asking this court to do is exactly what it did in the Posick v. Layton case, which we cited in, I believe, in the reply brief, where this court reversed the trial court and said, this conduct did not occur until after Dr. Layton had first breached the agreement. One need not continue to perform a contract when the other party is first breached. That is exactly what happened in this case.
Did your client give notice to the clinic of the breach as required by the operation agreement?
The operating agreement doesn't require notice. Only the member employment agreement under Section 6 required notice. And even if he did give notice under an April 4th email. But
he announced his resignation.
Actually, no. The April 4th email was about 21 days before he announced his resignation. He sent an email on April 4th to the members specifically discussing the K-1 tax issue and saying, I want a distribution. That set off 2 special meetings.
Yeah.
After which they offered to pay it.
They did not. And on that point, OHC makes that response. And what I'll say to that is that that issue is set in stone, that the trial court found they did not make an offer to pay. Had they did, the trial court could not have found a material breach of that operating agreement. Now, if OHC wanted to challenge that, they should have cross-appealed it. They did not cross-appeal that portion. And I would also argue that the evidence was pretty clear that they did not make an offer to pay. The evidence that's cited by OHC in their brief cites Dr. Alonzo's testimony on this point. Dr. Alonzo's testimony clearly matched my client's testimony, in which he said they made an offer to pay only one or this Dr. Maida issue. They required him to waive rights regarding the Dr. Maida issue in order to get that tax distribution, which is a clear violation of Section 6.2. It doesn't say you get a tax distribution if you release other rights. It's not what it says, and the trial court agreed with us on that point. One of the other responses that I'll address by OHC is that first they argue that this tax distribution issue was not pled, and therefore the trial court never should have found that. Again, that issue was not cross-appealed, so it's our position it's set in stone for purposes of this appeal. And secondly, it doesn't matter because even OHC acknowledges it was pled in the second affirmative defense by Dr. Zhang. He expressly said, you cannot recover the balance of the membership interest because of a prior material breach based on the tax distribution. So we get to the same place. It was properly before the court, and the court made a decision. And the last issue is that the tax distribution, the last issue in response is that the tax distribution was not somehow material. $23,000 apparently is not material. Again, that issue is set in stone because the trial court said it was. It had to in order to find a breach of the contract because that is a necessary element, and that issue was not cross-appealed. So, you know, I'll finish with this point on that issue and move to the severance damages. What the trial court has in effect left us with is requiring Dr. Zhang to pay $270,000 for a membership interest, which he's now relinquished, while at the same time, OHC inexplicably can just not pay the benefits of that membership interest, which is the tax distribution.
Would his obligation be different had he signed a promissory note? Would that have made a difference?
Not in this context, no. It might in one of the other arguments that I've argued. But even if he signed a promissory note, they would have committed a prior material breach, I believe. Okay, let me move to the severance damages. In count one of the amended complaint, my client sought severance damages of about $100,000 from OHC. The trial court denied that relief because they said Dr. Zhang committed a prior material breach of the member employment agreement by not providing 180 days notice, when in fact he provided only 45 days notice. And I should mention this, severance damages, this is not severance in the traditional sense. This is money that he actually worked for and is earned, but just gets collected after he leaves the practice. The error here is that I guess twofold. One, the trial court already found, pursuant to count one of the counterclaims, that the failure to provide 180 days notice was not material. OHC sued for $172,000 in damages. They had a whole category in paragraph 8 of their counterclaims of the type of damages they thought they were owed. They got absolutely zero. And not only did they get zero, the trial court said, you actually could have been more profitable when he left. And the reason is because Dr. Zhang didn't go to a competitor. He transitioned his patients to everybody else in that practice and went to do a fellowship. It's our position that as a matter of law, once the trial court found you took your shot at proving damages on this issue, absolutely none, it's not material. It cannot simultaneously be a material breach of that same document, preventing Dr. Zhang from recovering severance damages.
Didn't the trial judge decline to award damages because damages would be speculative?
That's correct.
On that count? But did he not also affirmatively find there was a breach?
He did find there was, I don't know if he used that exact language that there was a breach, but he definitely found that they were the prevailing party on count one of the counterclaims.
So then how under that, if that's the case in the trial court, how would that foreclose a determination of materiality?
Because materiality requires that the breach go to the essence of the contract and it be of such significance that it relieves a party of further performance. I don't think you can present evidence on trying to show why something is a breach and completely fail in showing any detrimental effect and then still be able to say that was so significant that you cannot recover $100,000.
To be fair, though, I mean, the record does provide evidence of a detrimental effect insofar as there was testimony about how difficult it is, to find, a stand-in doctor or replacement doctor to reorganize your practice when you have someone leave, and that's, a reason for asking for lead time, right? So, I mean, why does materiality hinge only on, economic damages? And not, a party can include something in a contract that, its breach may not produce damages, but nonetheless could be very important to the party, could it not?
That's a good question. To be clear, it doesn't hinge on economic damages. I can envision a scenario where you cannot prove recoverable damages, but it could still be material. The problem, though, is that they produced absolutely zero evidence of any detrimental effect regarding his notice. And I went through this in the reply brief. OHC argued there was problems with patient transitioning, patient notification, and the recruitment and replacement of physicians that was all affected by Zhang's failure to give notice. Absolutely no one testified to support that. Literally no one. Dr. Alonso testified and was asked on cross-examination, name one patient you lost, name one problem you had in communicating with the patient, couldn't name one.
Is materiality determined by the effect of the breach after the fact, or is it determined by, the reasonable expectations and understandings of the party at the time of contract, right? So one could conceive that it could be possible that when the parties are forming the contract that they anticipate, yeah, this is a very important provision because we could have all of these problems if this provision is breached. And then, auspiciously, it just so happens to be the case after the fact that, phew, we didn't have to encounter those problems. Is the relevant test for materiality determined by, sort of the Monday morning quarterbacking, looking back at what happened after the fact, or the reasonable understandings of the parties at the time of contract?
I'm not aware of a case that says one way or the other, but I think you have to look at both. I think common sense compels you to say, just because the contract says you have to write in blue pen and you don't, we have to look at what was the effect of that. And I think if you look at the evidence presented, not only was there not competent substantial evidence, there was literally none. The only, Ms. Hodges, the practice administrator, was the one who testified, I think the testimony that you're alluding to, and said, well, the reason why we include this is so that we could have time to go get another physician. She wasn't there from 2014 to 2021. She had zero personal knowledge of anything. On the issue of recruiting a physician, Dr. Mehta was the only one who actually testified about what happened at that time, and he testified they weren't looking for another physician. He literally said, we were okay with it. We didn't want to go get somebody. And that's in part what led the trial court to conclude that they could have been more profitable. Even 4.5 years later, when the trial occurred, they still hadn't hired another physician. So I think, to answer your point, you have to look at the actual facts, and there's got to be something underlying the materiality. The court is taking away $100,000 in earned income. There has to be a basis, a factual basis to do that. And I think the Burlington court opinion from this court sums it up. You cannot have trivial noncompliance and minor failings. The only way you determine whether something is trivial or trivial noncompliance or minor failings is actually look at what occurred. And when the trial court, if the trial court had done that, and if this court does that, I think it's compelled to find that it was not a material breach. I'll just quickly
follow up on the earlier question. Do we look at materiality as of the date the contract was entered into or the date of the breach? Because when they wrote the contract, maybe recruitment and retention of physicians was a big deal and it was material. That's why they wanted 180 days notice. Your guy gave 25% of that.
Yeah, I think you need to look at least the date of the breach. A lot of things happen over the 2 years that a contract is signed.
So then whether a breach is material can change throughout a contract period based on the prevailing facts at the time of the breach, such that conduct, the exact same conduct, can be considered a material breach at point A during one's employment, but during point B, it can cease to be material because intervening facts have changed. That would be essentially the implication, the necessary implication of your argument, right?
Absolutely. I can think of a scenario right now where they sign an operating agreement and they say, we need 180 days notice to hire a physician. A year goes by, they decide we will never have more than 5 physicians. We've now decided it's too much work, it's too much administration. They pass a resolution, we're not going to have more than 5. That changes the scenario. All of a sudden, if he doesn't give 180 days notice and it's because they need a physician and they still have 5 physicians, let's say, it doesn't matter. We have to look at the actual facts and how it played out in order to determine materiality. It is necessarily a question of fact, and that is the law. You know, it is. The trial court has to have competent, substantial evidence, factual evidence to support it. Very
Did
briefly.
you make the argument as it pertains, did you make the argument to the trial court below that the finding of the doctor's breach of the 180-day notice is inconsistent with the trial court's finding on count 1 of the counterclaim? Did you make that argument below?
I do believe it was in the written closing argument and also in the motion for rehearing.
Okay.
The written closing argument was 40 pages. I'm pretty sure I threw everything in there.
Okay.
Given the time, I'm going to briefly jump to the Chapter 517 claims and just focus on two big issues. First, I'll talk about the Paddock Park mortgage and the distribution, which
Was
is,
it ever denied records? Did he ever specifically ask for any type of financial records and was told no?
the testimony, no, not as to records. He did testify that he asked to sit in on the member meetings immediately prior to his buy-in, and he was told no.
Did they ever let a non-member sit in other than your client?
My recollection of the testimony was no. No, they did not. And what I think, just briefly, what makes this claim a little more distinguishable than others and makes it a little more compelling, in my opinion, is one, the timing. We're talking about this massive distribution and increase in debt literally the day before he buys in. And one of the arguments I made repeatedly is Dr. Zhang cannot possibly know to ask for that information. He needs to be affirmatively told that information, and I think that is a requirement if they're going to prove an exemption under 517.061. The second part that I think is compelling is that they admitted at trial that he had no right to know this information. Dr. Mittal testified that he as an employee, non-member, he wasn't entitled to it. Dr. Alonzo stated generically that he could ask for anything, but then when his own attorney asked him, what about the distribution information? Would that go to a prospective member? He said no, non-employee positions do not get that. And then finally in the answer brief, they've doubled down on that and said as an employee, he wasn't entitled to this information. And I think that is just contrary to Chapter 517. In this situation, for a security, a purchaser is entitled to know. He can make his own decision on something like that, and he couldn't possibly know unless they told him. The second issue, very briefly, is the buyout liabilities. Here he was affirmatively told those buyout liabilities would be paid off. They weren't. He expressly asked about them in the context of buying in. The two individuals, managing members, didn't come, testify in distinction to that. They didn't appear at trial. I think the record clearly established a violation on that point. Thank you.
Mr. Remmenschneider.
Judge, how are you?
Good, sir. How are you?
Good, sir. Mike Remmenschneider for the appellees, O'Callaghan and the doctors. May it please the court. I tried this case. I tried the case over 2 days. I think there's been some misstatements made, actually. There was a very clear finding by the judge that there was a material breach of the counterclaim by the failing to give the 180 days. And the 180 days, I think, has to be measured at the time of the contracting, not at the time of the breach itself, because that would essentially amend the contract, and there was no amendment to the contract, and that would be like, basically, you're not following the contract. The contract had to be determined, the 180 days had to be determined as material at the time of the contracting itself.
So I think your friend on the other side is making the point that materiality must be substantiated by some sort of factual evidence. So if materiality is to be determined at the time that the contract is entered into, then what are the sort of facts? First of all, would you concede, do you agree with your friend on the other side that there have to be supporting facts, to support a finding of materiality? And if so, can you tell us which facts at the time of the contract,
No,
contract's execution?
I don't agree with that. I don't think the cases talk to that issue of the issue as to whether you have facts that show materiality. I think the parties define the materiality at the time of the contract themselves, and they have the ability to negotiate the contract, and they could have negotiated something different. Now, they had, and there was evidence that of why the 180 days was put into the contract. Both Dr. Alonso testified to it, and the administrator, Michelle Hodges, testified to it, that it's very difficult to find a cardiologist, an invasive cardiologist, in Ocala, Florida. There are a lot better places to find, Ocala or find cardiologists to go. And so they have to have that 180 days, and they have actually put it into every contract of every doctor that has ever worked at that particular facility. So the reason they have it is because it takes 6 months at least to bring somebody in to actually advertise that you want somebody to be brought in. So they've had issues in the past with this 180 days, and they need every bit of it. And they testified that they needed every bit of that 180 days, and they in fact interviewed doctors during that time period and were unsuccessful in actually hiring a doctor. Now, Dr. Maida came in, and Dr. Maida is a brand new doctor, and he said years after the fact, well, it was okay that we didn't hire somebody. But the reality is they tried to hire somebody the whole time that Dr. Maida was a physician at the facility. He is still a physician at the facility. So Dr. Maida had his own opinions about things, but the fact of the matter is the administrator and Dr. Alonso, who was the president of the company, continued to look for, and were looking from the very get-go for a cardiologist to fill that spot, and they would fill that spot if they could find somebody. They haven't found somebody to this day, and they continue to interview to this day. So it's a situation where materiality was measured by the parties at the time based on their expectations. They could have negotiated a different time period, and they did not. And I don't think they would have even accepted Ocala Heart a change in that provision because of the difficulty it is to find a cardiologist in Ocala, which has, oddly enough, quite a number of cardiologists in the area. So it's difficult to actually find one that fit that niche in that area for some reason. So that's why the 180 days was so important.
So if damages are an essential element to a breach of contract, how could there be a breach without damages, much less a material breach, if you're unable to prove damages to the court's satisfaction?
Well, the court found that there was a material breach and that there was harm. He actually put it into the final judgment that there was harm that was suffered because of the failure to give the 180 days. And the court actually found, and let me find this for you, actually found that that Ocala Heart had been deprived of the overhead that Dr. Shung brought to the business for those days that he did not give notice. The court just found that there was harm, that there was a material breach. It just didn't find that we met our burden and showed that there were damages in the way of proof. We didn't take into consideration from the court standpoint the other side of the argument, meaning we looked at the overhead and the damages, but the court wanted us to look at the issue of, okay, how much did he earn during that period, putting it against the
court saying there could have been damages, but you just didn't prove it, as opposed to saying the damages are non-quantifiable?
That's correct.
If you did not demonstrate damages, if you did not meet the burden of proof for damages, and damages being an essential element for a breach of contract cause of action, if an element has not been proven, how can the party asserting the counterclaim be a prevailing party?
Well, because I don't think that the court said that we didn't prove harm. We proved harm, we proved damage, we just did not prove the extra step of an evidentiary issue of speculative damages. We just didn't prove that element. But the court clearly said there was harm that was suffered and that there was a material breach. So I think the elements have been met so that the court can say, yes, I think you're the prevailing party. However, you didn't have all of the evidence that you needed in order to prove that last element, that last speculative number. Some of the other things I wanted to address, Dr. Alonso testified very clearly on page 286 of the transcript itself that he would have disclosed to Dr. Shung, if on page 286 of the trial transcripts, he asked, now the refinancing, where the members take out a piece of the equity, if we will, is that something that's kept secret? Answer, no. Is that information available if it is asked for? Answer, absolutely. So he did not hold back any information. The distribution, the refinancing, Dr. Shung knew about the refinancing. He just didn't ask because he didn't want to know. He didn't care. He wanted the $60,000 to $70,000 extra he was going to get every month, and that's what he was focused on. He was not focused on financial documents. He had the amortization schedule. He had the agreements. He had talked to people over the 2 years he had been there as an employee, and he decided not to talk to anyone or ask for any documents. What are we supposed to do? Spoon feed him? Are you supposed to give him the documents? I don't agree with counsel. I think you have a burden as an adult, as a physician, as a cardiologist, as a contracting party to say, wait a minute, I need to get some information. And he didn't ask for that information. So that information was there. It was available. The physicians were available. He spoke to physicians. The court made a specific finding that he spoke to the physicians, and that contradicted his testimony that he didn't have the ability to talk to anyone when he wanted to, and that just wasn't true. And a lot of the things that were mentioned, and I could go through each one of them, as far as some of the things that counsel brought up. Let me see where I put it. So I've touched on the issue of the page 286. The other thing that I disagree with, and it wasn't raised in the brief, but it was raised in the trial, and it was raised in the pleadings as an affirmative defense. The K1, the material breach that they say is a material breach, which I say is a non-material breach, where they say $23,000 was owed and was not paid to the doctor for the K1. Well, the fact of the matter is, the evidence is very clear that, and the judge finds a specific finding in his offended final judgment, that he in fact was given the option to accept the K1 money, and he rejected it. So I don't even agree with the trial court on this issue, probably watching me at the moment, but I didn't agree with the trial court at the moment, and I don't agree with them now because the money was offered. He did not accept it. That was his call. That was his decision.
But you did not cross-appeal the award of the $23,000.
I did not cross-appeal the $23,000, but let's be clear. Was it in the pleadings? No, it wasn't. Is it in count one? It's of their complaint? It isn't. It's not something that they raised in their closing or in their proposed final judgment. This was something that the judge gave to them gratis, which I didn't even have a chance to argue about, because he gave it to them after the proposed judgment and the closing had been provided. And so, no, we didn't appeal it, and I understand that part of it. But to be clear,
Had you appealed it, perhaps they could be arguing today that, in their response, that it was tried by consent. It was in our affirmative defenses. We talked about it throughout the trial. They don't get that opportunity if you didn't cross-appeal. So why are we talking about it?
well, I think in a trial by consent, you got to say something. You got to say, Judge, I moved to amend my pleadings based upon the fact that we've tried this case by consent and tried this issue by consent. That had never happened. So we went to the closings, we went to the proposed final judgments with this never being an issue. This was solely something that was selected by the trial judge. But it is what it is. We accept that the fact that the amended final judgment reduces the number that we were entitled to by $23,000. That's not really challenged.
What importance do we place, if any, on the fact that Dr. Zhang signed no promissory note?
Well,
Dr. Alonso said, yeah, we screwed up, basically. It was an oversight on our part.
Dr. Shung did not sign a promissory note. He was not presented a promissory note, but he was asked repeatedly at the trial, did you agree to the amortization schedule? Did you agree to pay the monthly payment? He's answered yes. And he agreed throughout the entire case that he agreed to this amount of money. Promissory note doesn't change the fact that there was an obligation to pay. He made 10 payments on the actual payment schedule, so I think he's obligated.
Then he gave back the membership units at some point.
He did not give back the membership units. He tried to rescind. We took them back pursuant to the final judgment. When we changed the spreadsheet, we took them back, but he tried to rescind the deal. He still had the units, it was his argument, but he really did not. With that, I'll conclude unless there's any additional questions. Thank you.
Thank you. All right, just under 3 minutes.
May it please the court. I'll start with what the court just finished with. There was no executed promissory note. The only thing that was presented at trial to support that Dr. Zhang has a personal liability for the amount owed after he returns the interest was Section 7.4 of the operating agreement. That document doesn't say that. It specifically says he owes what is owed under the Zhang promissory note, which doesn't exist. There was no testimony regarding he agreed to pay that after he returned it. The evidence was they redeemed the interest sometime shortly after he resigned, not at trial. All they had to do was make an internal adjustment to a spreadsheet to redeem the interest, which is what they did. There's a reason Dr. Mehta, who bought in 3 months later, executed a pledge agreement and a promissory note. So it was clear in writing what he was obligated to pay. I want to touch back on the question that was asked about evidence supporting materiality and when you look at it. In effect, what OHC has said is we presented theoretical evidence of why it could be material. That's all they did. They didn't present actual evidence as to why it harmed them or did anything to them. And I think the trial court is compelled to look for actual evidence. Imagine a scenario where my client gave 175 days instead of 180. How is the court going to determine whether or not that is material or immaterial? It's going to look at the facts and say, well, explain to me why 5 days matters. It's going to ask to show me some sort of evidence why you needed 180 as opposed to 175.
How does your approach avoid conflating materiality with the separate element of damages?
I'm sorry?
So to recover, you have to prove a material breach and damages. How does your approach not conflate the two, materiality and damages? How do you distinguish between the two?
Again, I agree that you could prove a breach and not prove damages in some theoretical manner. But what I'm arguing is that twofold. They also didn't present any evidence whatsoever to support a material breach, because that was one of their affirmative defenses where they bear the burden to prove. So not only did the court find what it found on count 1 of the counterclaims, they also didn't prove evidence of materiality. And the last point I'll make on the prevailing party issue, which I didn't get a chance to touch on, here's how the Cannon case described. The prevailing party the determination rests on whether the party succeeded on any significant issue in litigation which achieves some of the benefit the party sought in bringing the suit. They sought only damages of $172,000. They got 0. I think the trial court abused its discretion on that part. Thank you.
All right, thank you all very much. Well briefed and well argued case. Before I let you go, do any of the students or faculty have questions for counsel in this case? Okay, thank you all very much. At this time, the court will stand in recess.
All right.